Hi, I'm Nate Freed Wessler. You're listening to Firewalls Don't Stop Dragons.
Hello, everybody. Welcome back to Firewalls Don't Stop Dragons. I'm your host, Gary Parker. Today we have episode 488 for July 6th, 2026. I hope everybody in the U.S. had a great 4th of July, saw some really cool fireworks, had some fun food, whatever you did to celebrate. I'm actually recording this before the 4th of July, so I don't know how much of a good time I had at 4th of July, but knowing what I'm going to be doing, it should be a lot of fun. So today we've got a wonderful interview with you. I'll be talking with Nathan Freed Wessler from the ACLU. I talked to him some time back about location tracking because he was the person who argued the case for Carpenter v. United States in front of the Supreme Court and won. And that prevented law enforcement from just asking for our location data from cell phone companies. Seems kind of quaint now because there are so many other ways that we are tracked. And we will talk about that some today. But we're also going to be talking about border searches and law enforcement searches in general of our digital devices. Warrants for physical spaces are very different, and the law is basically based on that concept and is trying to catch up to the digital world where so many of the things that we are carrying with us now are portals into much, much more personal data, not all of which is actually stored on the device. And why it's such a weird thing that when we go to the border and the border agents are trying to make sure we're not bringing in contraband, how that applies to things like digital stuff. So it's a very fascinating conversation. I'd love to talk about this legal stuff. But one thing before we start, I will say, keep in mind that most of the legal aspects of the discussion that we're about to have apply only to U.S. citizens, and it only really applies when that citizen is returning home from a foreign country, when we're talking about border searches anyway. Non-U.S. citizens have very different rights when crossing into the United States, just like we have totally different rights when we enter the customs or border of some other country. But when we get to practical tips for how to travel with your phone and your laptop and things, that really will apply just about anywhere. So I'm excited. Let's get to our interview with Nate Wessler. Nate is a deputy director for the ACLU's Speech, Privacy, and Technology Project, where he focuses on litigation and advocacy around surveillance and privacy issues, including government searches of electronic devices, requests for sensitive data held by third parties, and the use of surveillance technologies. In 2017, he argued Carpenter v. United States in the U.S. Supreme Court, a case that has established that the Fourth Amendment requires law enforcement to get a search warrant before requesting cell phone location data from a person's cellular service provider, something that we are going to get into a bit today. Welcome back, Nate.
Thanks so much. I'm really happy to be here.
I'm really happy to have you back. I've been thinking about bringing you back for a long time. I'm glad we got this to work. We've got plenty to talk about. We could have picked any number of topics, but today we're going to talk a little bit about border searches, which I've talked about before, but not with a lawyer. So I'm looking forward to hearing what you have to say about this. And we're going to also talk about some location tracking and how those things might interact now, and maybe get an update on Carpenter-ish stuff. So let's start with some basics. Why is the border special? Is there a legal basis for why we apparently lose some of our Fourth Amendment rights in this zone? And specifically, what's different about how searches work at the border versus elsewhere?
Yeah, so maybe I'll start with the second half of that first, right? So, the normal rule under the Fourth Amendment, the Fourth Amendment, start from very basics, right? Fourth Amendment, part of the Bill of Rights, it requires, it's the part of the Bill of Rights that regulates police searches and seizures, right? It says that if police want to conduct a search or a seizure of our persons, our houses, our papers, or effects, it has to be reasonable. That's the first half of the Fourth Amendment. And the second half talks about what the requirements are for a search warrant. And then there's, centuries of case law interpreting the Fourth Amendment. And the basic rule is that when the government, particularly police, but really any part of the government, wants to search our stuff, our private spaces, private containers, right, bags, homes, our persons, the basic rule is they got to go get a warrant. That means go to a judge, show probable cause that the suspect committed a crime, show that evidence of that crime is likely to be in the place to be searched, show there's a connection between that evidence and the crime, and then get a narrowly tailored warrant that says, okay, you can search in the medicine cabinet for illegal drugs. You can search in the garage for a firearm, whatever it is, right? Should be constrained and have judicial review. There are some contexts where courts have said, actually, because of some particular reasons in this context, we're not going to require a warrant. We're going to suspend the warrant requirement. One of those examples is after you've been arrested, the normal rule is police can search your person without a warrant, right, after a lawful arrest, right, and take anything that's on you and look through it. Now that, just like the border search exception I'm going to explain in a second, that's come under tremendous stress in the digital age. But it used to be police could look through your wallet, your cigarette pack, whatever's in your pockets. And, that's an invasion of privacy, but it's not a huge one once you're already under arrest, right? You're already in government custody. The problem is if you're carrying a cell phone, now you have your entire digital life. What should the rule be? And the Supreme Court actually has said the rule is get a warrant there too. Police can seize the phone during the arrest, but we're going to say a new rule for digital age. In the border context, that's another context where the Supreme Court has said that normal warrant rule is going to be suspended. And the reason for that is the court has said that both people have a lesser privacy interest at the border because they expect to be examined to be able to get into the country. But more forcefully, the Supreme Court has said, regardless of how much of a privacy interest you think you have, the government has an overriding interest in assessing who and what is coming into the country and to keep out stuff that's not allowed to come in, contraband in particular, right? Make sure that people are paying import duties or not bringing in fruits and vegetables that might have parasites that aren't allowed, not smuggling in illegal items, etc. So there are a set of cases going back a very long time from the U.S. Supreme Court and lower courts that have established the authority of the government to search our physical luggage or anything else we have with us when we come to the border, just because we're at the border. And so that's why if you've ever taken a trip out of the U.S. and come back in, you go through passport control and then you get your bags and you have to walk through the customs inspection area. And now most people can just stroll through, but the government claims the authority to search every and any bag at that customs check just because you are coming into the country. They actually claim similar authority when you're leaving, although that's much less common to do those searches. Now, the problem that we've encountered in the digital age, of course, is that people are now no longer coming into the country just with a suitcase full of, clothes and keepsakes and maybe some paper, but you're coming in with laptops and cell phones, smartphones, that include both a diversity and a depth of information that is literally unprecedented in human history, right? Like when this rule was created, nobody expected that you would have all of your family picture albums, all of your intimate photos, all of your financial records, every piece of correspondence from the last who knows how many years, and on and on and on. And so we are now faced with this question, should the government have unfettered power to look at all of that just because you want to come home from a vacation abroad? Or do we need better protections because the privacy interest is just incredible there?
Another aspect of this that has always kind of fascinated me and honestly terrified me, and it's not super well known, though I've talked about it on this show myself, is that the quote-unquote border is not really just points of entry. The border zone actually extends deep into the United States, and it turns out, and this is from a diagram that ACLU has put up for many years, that it affects nearly a third of the U.S. population because it's 100 miles deep. First of all, do I have that right? And then I guess also another weird aspect to it, and I ran into this myself coming back from a cruise in Alaska, is I actually went through customs and border stuff in Canada. I assumed that it's like an embassy or something. It's like U.S. soil, and they could kind of do the same thing there. But walk me through those aspects.
Yeah. So that's a great question, and the answer is important to understand, what our rights are where. So the border, quote unquote, the border, means the actual physical border of the U.S., which is the land borders, also the sea border, right? If you have ships coming in that have been out of the country, there are international seaports, but the whole coast is technically a border. So that's obviously the border, and there are ports of entry at the border, right? Highways and roads coming into the U.S. from Canada and Mexico, where there are entry stations you have to go to. And then there are all the spots in between, right, that are also the border. So someone stopped anywhere on the literal border, of course, subject to a border search. The international arrivals area of international airports are also the border, right? So the passport control and customs checks that you have to go through coming off an international flight also counts as the border. It's the functional equivalent of the border, but it's the first place you touch in the U.S. Elsewhere in the international airport, once you're through that, you're no longer technically at the border, right? You're just in the US, but you have to clear that border check to get there. You mentioned going through US customs and immigration checks actually outside the country at an international airport.
Yes.
That's called pre-clearance. And the US government has negotiated agreements with a handful of countries to move the border check back to that airport instead of doing it here. So, people have, you've gone through security at that airport and you walk into a special area that's just for flights to the US, and you're in the secure area of the airport. And it's a way basically to shorten the wait in the US. It's a kind of like sort of like a clever hack to just like swap the spot. And the idea is that like, you clear the immigration and customs check there, and then you're just sitting in a waiting room and you can't leave it. And so you get on the plane and then you arrive in the US in the same state you were before. Now you could be pulled out of the boarding gate when you arrive at the US and subject to a new border search. That's possible, and it happens occasionally. But usually it's just you've satisfied, you've shown your passport, you're okay, and you basically come to essentially like the domestic arrival area of a U.S. airport and just go on your way. So it's nice and convenient, and it just shifts the place you do it from one side of the flight to the other. Now, you asked a very good question about this so-called 100-mile zone.
Yes.
That's very important, but not for the purposes we're talking about here. The government, and this is really important to understand, the government does not have the authority to go search your bags or your electronic devices willy-nilly because you are within 100 land miles of a land border or a sea border of the U.S. What the government claims is greater authority to stop vehicles, to check documents, and do other kinds of immigration status checks within that zone. And that can be very abusive, right? There are thousands of thousands, hundreds of thousands, millions of people who live in the southern border states, in Texas and Arizona, Michigan, and northern border states. I'm from Maine, whose lives are interrupted over and over and over again by immigration agents stopping vehicles, demanding to check IDs, right, to check for citizenship status. And it often actually creates the conditions for racial profiling, because often the border agents are exercising discretion in pulling over brown drivers and not white drivers. So there's a lot of violation of rights that can happen in that 100-mile zone, but the government absolutely does not have some kind of extra authority to search our private stuff there. And in fact, I've never seen the government even claim that authority. They seem to recognize that a border search is really about catching someone at the border.
All right. You kind of talked about what a regular old-style pre-digital device warrant looks like. What are border agents allowed to search? Like, how are digital devices or device searches different from physical searches? Like, I've always wondered, like you were talking about how narrowly tailored a judge warrant usually is. And how does that even work on a phone? Like, can you say, well, you could just look at the person's emails for last week? Would that be part of a digital warrant, or are they different in that regard? Tell us how these differ.
Yeah, great question. So, in the normal law enforcement context, right, police get warrants to search cell phones and laptops all the time. That and houses are probably the most common things that police get warrants for in 2026. And yes, it is absolutely a requirement of and a common feature of digital age search warrants that the judge constrains the scope of that search. And you can do that in different ways, and it's going to be totally contextual according to what the investigation is and what the probable cause showing is and what evidence police have good reason to say is on that phone. So date ranges are very common, right? Police are investigating a crime that happened in one particular week, and there's no reason to think that evidence of that is going to have popped up on the phone earlier. Then there should be a date at which they can start the search for, right? Yeah. And maybe a date that it ends, limiting to certain types of files, certain search terms. In regular law enforcement searches of phones, it's all done with forensic search technology, right? So police seize the phone, they have their warrant, and then they plug the phone in to some forensic extraction device that makes a bit-for-bit copy of everything on the phone, a mirror image copy, and then they secure the phone, right? And then they start running their searches on that copy. And this is just with very, very advanced forensic search tools, which can obviously do keyword searches, sometimes image searches, limit by date range, limit by type of file, limit by all kinds of metadata. And that means that judges can help constrain the scope of the search to be consistent with what the government actually has good reason to think is evidence of crime. And so, in a search with someone suspected of tax fraud, probably family photos should be off limits, right? You should be searching PDFs and Excel files and maybe emails, right? But photographs, unless there's some particular thing about that tax fraud investigation, there's no reason to think that automatically should be in bounds. So that's very common. At the border, there are two kinds of searches that the government will do. And in fact, Customs and Border Protection and Immigration and Customs Enforcement, the two parts of DHS, Department of Homeland Security, that deal with the border and immigration enforcement, have a policy about this. So there are two kinds of searches. One is called what they call an advanced search, which most of us call a forensic search, which looks like that criminal investigative context. They take your phone or your laptop, plug it into an extraction device, take everything off of it, and start running searches on that. They also do what they call basic searches, which sometimes we call manual searches, where you just have an agent, usually there at the airport or at the border crossing, manually going through the phone, right? Like thumbing through the phone or poking around the laptop. But that can include using the native search function in the device, right? So, I have an iPhone and you just, swipe your finger and there's a little search bar. And so they can do text searches directly on the phone. Those searches often you can do like text to image searches, right? Show me faces or canaries or whatever it is, right? So there's actually a lot that they can do that increases the efficiency and therefore the invasiveness of those searches. And there's no time limit on them. They can be sitting there for minutes or hours plugging around in that phone without it even being a true forensic search. So we can talk about kind of what courts have said in a second, because there's a patchwork of decisions. But this government policy, this DHS policy, has slightly different rules for these two kinds of searches. They say for manual searches, basic searches, anything goes. The fact that you're at the border means an agent can look for whatever they want for as long as they want and make records of it, right? Make notes about it, put those notes in a database.
Can I ask one quick question?
Yeah.
Because one of the things I've heard is, and I don't know if this is true, but I read somewhere that border agents were only allowed to search what's actually on the device, like not what's in the cloud. Like sometimes the agent themselves will supposedly put it into airplane mode.
Yes.
Which means that there should be cut off from searching anything that's in the cloud. Is that
is accurate? I've certainly heard reports of violations of that rule, but that's the rule. That's the rule according to the government's own policy. And it's a rule that comes out of actually the Fourth Amendment interpretation here, where the government recognizes that even their most expansive claim of authority only gives them the right to search stuff that's actually crossing the border. And so, it's, I guess the analogy before digital age technology is, they can search you and ask you questions as you're coming back into the country, but they can't make you make a phone call to your bank and ask for your current balance and then report it to the agent, right? Similarly, they can search, they claim the authority to search stuff that's on your device, but anything that's in the cloud that the device can access but is not downloaded to the device is off limits. They are supposed to put phones and laptops into airplane mode. We'll talk about some kind of know your rights advice probably at some point, but that's one of the things that you should do, actually. You should just put it in airplane mode yourself before you walk up to that counter. And that's just, a better protection that they're not going to be sloppy and, inadvertently fail, maybe intentionally, maybe accidentally fail to toggle that airplane mode before they start poking around.
Yeah, we'll definitely get to that.
Yeah. So I was saying for these basic searches, they just claim total authority to look at whatever they want. For forensic searches, they claim the same authority to look for whatever they want. The only protection they recognize is that they say they have to have reasonable suspicion of some kind of wrongdoing before they do it. Now, that reasonable suspicion is extraordinarily broad. It could be a violation of any law whatsoever, any criminal law at all, or any border-related offense. Doesn't have to be reasonable suspicion even that the phone contains evidence of that offense. It could be that they think that the phone contains, a contact list that might shed light on someone else's, offense, but they have reasonable suspicion. So it's a very thin protection, although probably better than nothing. But otherwise, the government really doesn't limit itself in what it can look at, how long it can search, and what it can do with that data.
So just thinking back on what you said before, what's the rationale behind searching digital devices? It's not like I'm smuggling bad bits into the country, right?
Yeah, absolutely.
What are they saying they've got authority to search for because it might be dangerous or there's nothing I couldn't bring in a phone that I couldn't do remotely.
Yes.
Because it's all digital.
That's exactly right. And this is an argument we made over and over to courts. So several years ago, the ACLU, along with the Electronic Frontier Foundation, EFF, brought a lawsuit against the federal government on exactly this issue, saying that these suspicionless, warrantless searches of our electronic devices violate our Fourth Amendment rights. And we got to discovery in that case, and we're able to take depositions of high-ranking CBP and ICE officers, and we got a bunch of documents. And through that, we got concessions, admissions by the government that a whole range of things that they claim the authority to search our phones for. So it's certainly not just for like literally illegal materials, contraband. It includes searching a business person's phone for information about some business associate of theirs who is suspected of violating an import law. It includes searching a U.S. citizen's phone for information about family members who are undocumented or have some other immigration status. They claim the authority to search phones for intelligence gathering, right? Not even criminal matters. They claim the authority to exploit the happenstance that you're coming back into the country to search for evidence of wholly domestic crimes, right? Exactly the stuff that the government clearly has to get a search warrant for if they go to your house. You live in Portland, Oregon, and they want to get your phone, they got to go to a federal judge in Portland, Oregon and get a warrant. But you live in Portland and you come into the airport after a trip to China. Maybe the FBI has called their buddies at DHS and said, do us a favor, pull this guy out of line, and we want you to take a look what's on there. So they claim wide authority. Now, there is actually one federal appeals court, really two in the country, that have put some limits on those searches, recognizing exactly the problem you're identifying. So in the territory of the U.S. Court of Appeals for the Ninth Circuit, which is the whole western edge of the country, the government is only allowed to search phones at the border for the purpose of looking for digital contraband, which is a very narrow category. It would include it's files that are literally illegal to carry across the border, which would include a very short list. So child sexual abuse materials, which are in all circumstances illegal.
Right. Maybe
some classified materials, and maybe a very small set of other highly confidential materials that violate import or export regulations that could be in digital form. Everything else is evidence of something else. It's intelligence gathering, it's evidence of domestic crime, it's a hunch, and none of that is okay to search for within the Ninth Circuit. That's a good rule, because that tries to conform that search to the thing that police or border authorities have always been able to look for, right? You can open my suitcase to look for stinky cheese that I'm not supposed to bring in, or look for a stack of more than $10,000 in U.S. currency that you're not supposed to bring in without registering, or illegal drugs, whatever it is, right? That is contraband. Now, what we had pointed out in our briefs in many of these cases, and in fact, a federal district court judge agreed with us, is this thing you identified about how the digital context is just weird and different because there's no reason to think that you can stop importation of digital files by searching devices, because you just use the cloud, right? Like you'll catch a copy of that illegal image. Sure. But most abusive child sexual abuse material isn't coming in on phones through the border. It's coming over the internet, right? There's no way to stop that problem by spot checking people's personal files. Maybe the government will catch some people it wants to prosecute, but you're not actually, unlike physical contraband, that if you catch it, it doesn't come in, and there's no other copy of it. It's like it's a thing. That's physics. The physics of the digital world is just different.
Right. All right. Before we leave this, just because I watch too many cop shows, I just want to the manual search option when you're away from the border. If you've got a warrant to search someone's device and it's all right, you can search their emails, you can search their photos and nothing else, and maybe only in these states. If I'm doing a manual search, like when you watch the cop shows, when they go through someone's house and they're supposed to check the safe on the second floor, if on the way to the safe on the second floor they see some drugs sitting out, they're allowed to do something about that. Is there do they have a similar notion for, hey, I'm just thumbing through on my way to the Pictures app, and I was like, oh, here's a crime app. Yes. Let me look at that. Does that apply the same way?
Yes. I mean, there's a tremendous debate actually in the courts about that. So that's called the plain view exception. And as you described, right, in the physical world, if police are lawfully in a place, so they have a warrant to enter your house to look for stolen washing machines, and on the way they see lines of Coke on the coffee table, they're going to arrest you and they're going to seize that as obvious contraband because its illegal nature is obvious to their eyes. They don't have to do anything to it to know, right?
Yeah.
In the digital world, that's actually a very important question, because digital files are intermingled, right? And whether it's a manual or a forensic search, even a forensic search, right? It's the computer program gets you a lot of the way, but then a human's going to put eyes on stuff. And they're going to see a lot of stuff that actually isn't pertinent to the crime, right? Even, if it's a date range, you're still going to have stuff in that date range that is totally innocent. It's my text messages with my mom about coming home next weekend. And so there's a debate in the courts about what should happen when police happen upon something that's not relevant to the crime they have permission to search for, but looks like evidence of another crime. And the options the courts have adopted include everything from stop and go get a new warrant, right? Don't look anymore, get a new warrant for that new type of stuff. And some courts have said, go get a new warrant, and the stuff that you happen to see, you don't get to use that. We're going to wall that off because of this fundamentally intermingled and privacy invasive nature of digital devices. So you can imagine a rule, and this exists in a few courts, where police might kind of accidentally see evidence of something else, but they can't benefit from that happenstance in the digital context. They have to stop, get a warrant to do more search, but sort of wall off that stuff, and that's reasonable. In the regular law enforcement context, you actually don't really see manual searches very often because it doesn't produce evidence that is usable at trial, right? To go to trial, you need like a forensic copy and a chain of custody and be able to say like, nobody monkeyed with this, right? We can show that we made a perfect copy and this is exactly as it was at the time. So manual searches certainly happen, but that's generally not what warrants contemplate. They contemplate like a real forensic extraction. And police and prosecutors have a motive to do it that way because they want it to be useful later.
Gotcha. All right. Let's pivot for a second to location tracking. Obviously, this is something you know a lot about. And as we said, you successfully argued the Carpenter v. U.S. case in the Supreme Court around this. So I'm curious for a couple of things. First of all, what privacy rights were directly established by that ruling? Since that ruling, has anything changed? Because that's been some time ago. And then there's so many new ways to track a location now. Our cars have built-in cellular modems now, which is basically your car is now a phone. So should Carpenter apply there? Has that been tested?
Yeah, great question. So starting with like the basics of Carpenter. So Carpenter was a case, as you said, about government requests to our cellular service providers, the AT&Ts and Verizons of the country, for a record of where your phone has been over time, right? So starting with the basics, our phones are just radios effectively, right? It's a fancy radio that has to talk to a cell tower to make a connection to the network. Cell towers, the big cell towers you see out in the world, the actual towers usually have several, often 3, could be 6 directional antennas on them. Mm-hmm. And, some other kinds of cell towers, these kind of small cells, sort of 5G towers, sometimes it's just a single antenna. But regardless, every time the phone talks to one of those towers to send or receive a phone call, send or receive a text message, or for a data connection, you're watching the Knicks clips from last night, right? Talking to a tower. The phone company's making a record of which tower and which antenna, which directional antenna of that tower the phone's talking to. They have their own business reasons for doing that, for billing, for roaming, sharing, and for network diagnostics, right? They, cell towers get overloaded. They need to know whether it's time to put up a new tower. So they keep that record. Now that record, in one sense, is just a record of what phone is talking to what tower. But really it's a location record, right? Because you know where the towers are in space and time and what direction those antennas are facing and the geographic range that they cover, where the phone was. And, if you're driving through rural Nebraska on the interstate, there might be a tower every 10 miles, right? It's flat, nothing in between, there's not a lot of people. But if you're in a dense city or a dense suburb, there are a ton of cell towers pretty close together because there's a lot of bandwidth usage, just a lot of phones, and towers can only handle so much bandwidth. And there are a lot of obstructions, right? Glass buildings, concrete buildings, leafy trees, bodies of water. That all messes with cell signals, right? Radio signals. So you have a lot of towers. They cover small geographic areas. So knowing the pattern of which towers a phone is talking to and which antennas over time charts a really detailed almanac, really a map of where we've been.
Yes.
And you can infer from that, of course, what we're doing, right? Where do you stop after work? Where do you spend the night? Who are you spending time with? You correlate which phones are near each other. That's a very detailed picture. Prior to Carpenter, the government's position was that whatever that might tell about your life that's personal or private or sensitive, the Fourth Amendment doesn't protect it because it's not in your own filing cabinet or your house. It's on the servers of a company. There's a legal doctrine that came to be known as the third-party doctrine that said when you have interacted with a company, this is what they're calling the so-called third party, and that company has now your information that you have shared with them somehow through that interaction, we're not going to treat that as your data or things anymore. That is now construed to be the company's business records of some sort, not your personal information, right? Not under your control. And so you've lost all of your Fourth Amendment constitutional protection in it. And the implication of that is the government doesn't need a warrant when it goes for it, right? They can go ask the company through some other way. Could be a subpoena for cell phone records. There was a federal statute that required a court order, but on a very low legal standard, not like a warrant. And you can't complain under the Fourth Amendment if the government gets it from them. That came out of a pair of pre-digital cases from the 1970s, one about banking records, where the government was investigating someone for running an illegal whiskey still and not paying the whiskey tax. And how do you know if someone's violating tax laws? Go look at their bank records. So they sent
follow the money.
Yeah, exactly. They sent a subpoena to the bank. The bank turned over canceled checks and account statements. The person complained, said, "Whoa, that's really sensitive. You should have gotten a warrant." Supreme Court said, "Too bad for you. You should know that when you transact with a bank, they're going to keep copies of your canceled checks, and they have to keep account records to know what's going in and out. You should know that. You made a choice to do some banking. You've assumed the risk that they're going to turn this over." There's another case about dial telephone numbers that was similar. Now, the ACLU thought that was the wrong rule at the time. We filed friend of the court briefs, amicus briefs on the other side. But that was the rule for pre-digital records. And the question that came really to a head in Carpenter is, should that rule apply in the same way to these voluminous, highly sensitive digital age records and records that you actually can't avoid creating?
Right?
And the court agreed with us. What we argued is this is what a majority of the Supreme Court decided, is that we just can't mash that old rule onto this new technology. We got to actually look at the privacy implications anew. And the privacy implications are sufficiently new and troubling that we got to figure out what the right rule is. And the right rule, it turns out, is get a warrant. And that was, the court said, both because of how revealing and sensitive this location information is, right? And that never before in policing have police had this power to, like, effectively, as the court said, at the press of a button, call up a perfect record of everywhere you've been over. In the Mr. Carpenter's case itself, it was 7 months of data that the government wanted, an average of 101 location points per day. That's nuts. That's just not a thing a human could gather.
It's a lot of breadcrumbs.
Yeah, exactly. It's a thing technology enables. And then the court said, so it's sensitive, it's unprecedented, and nobody is actually making an informed choice to, like, create this record, right? Like, that case was decided in 2018. In 2018, like today, to be a modern human, you need a cell phone for work, for family, for safety, for social life, etc. And, once you have a cell phone, you can put it in airplane mode, and then you have a very expensive paperweight in your pocket, or you can use it as a cell phone, but then you can't avoid this being created. So nobody's opting in to the sharing, and therefore we have to find a way to protect this, and the Fourth Amendment is that way.
So how has that evolved since the ruling? Has there been any refinements on that? Has it come into play in any interesting ways? Like, again, with cars, because almost all modern cars have built-in cell phones now. Are those considered, did you have the same privacy records? The records of where my car has been, is that protected as well?
Yeah. So, courts are are all over the place and are grappling with all of these questions, right? How do you apply the reasoning of Carpenter to other technologies and other kinds of data that are more or less analogous? And so there are questions about other kinds of location tracking data that's held on different kind of company servers. And there are questions about other non-location data that's sensitive in its own ways, right? You can imagine you're wearing a smartwatch that collects body data, right?
Yeah,
Heart rate, blood pressure, et cetera. That's getting saved on a server somewhere. Surely that is, that's the most private, right? That like literally is like your body, like your nervous system is creating this. Should that be protected, and should a warrant be required? So there are, there's a set of records where companies have just by and large demanded warrants, and the government seems to have largely played along. And there are other kinds of data where the government is still trying to access without a warrant, and where courts are starting to get involved. But there's still lots of open questions. With other kinds of location technologies, courts, so, the way courts in a kind of common law system like the U.S. operate is often by analogy and by a kind of compare and contrast reasoning, right? And so the decision in Carpenter said, well, this case is about this duration and this amount and this sensitivity of location data that was shared in involuntary ways, in these fundamental ways. This gets protected. But it didn't actually explain, like, the rule for how you decide what other data gets protected or not. And so what a big part of my job and my colleagues is to try to explain to courts how Carpenter should or should not apply to other kinds of data. And so, in the location tracking context, one technology that is, hotly in the news today, where there are big questions, is automated license plate readers.
Yes,
right?
That's going to be my next question.
You asked about like the car itself, right?
Yep.
And I think there's a very strong argument after Carpenter that if there's granular long-term location data about where the car went that's held by, say, the car company or OnStar or whoever it is, that looks just like the Carpenter data. I don't know of a case that actually directly addresses that. But that's pretty close. Courts are now grappling with these license plate reader networks, right? Where the location data is not being generated by your device. It's not your car or your phone, right? It's being generated by these extensive networks of cameras that are taking pictures of every license plate that goes by, that are making that into machine-readable text, right? Using optical character recognition, time-stamping it, and GPS stamping it, right? So now, and feeding it into a database. So now there's a database, not just where I'm driving, but where every single driver is going over time. Every time you pass one of these cameras, and in many cities there are a ton of them, it makes a record.
And by the way, I just read an article. They're putting on moving vehicles too. I mean, cops have them on their cars, but also they're putting them on school buses now. Like school buses had them to try to catch people who went around buses when the stop sign was out. Makes sense. But now the companies are saying, well, as long as you're doing that, why do we get everything you drive by all the time?
Yes, and this is a feature of the commercialization of this technology, right? It's so, and this is true with so many surveillance technologies. There's an interface between the government and the private companies. And so that, the police department is not manufacturing their own surveillance cameras, obviously, and they're not building the software that tracks and databases the license plates and the locations, right? They're contracting with some company.
Yep.
And the business model that seems to have prevailed for these companies is that they're selling not only the hardware and the software that runs on it, but they're selling the database access.
Sure.
And to do that in a way that makes the most money, they don't just want to sell, they don't want to sell just to Charlotte, North Carolina, a Charlotte, North Carolina database, and to Raleigh, a Raleigh database, and to Durham, a Durham database. They want a database that's as big as possible, and they can tell police, you can search everywhere, and everyone else can search you too, and it's seamless. And so, several of these companies have gotten very big. Flock is the one that's been most in the news recently, for good reason, for some real abusive uses. There's another one called Vigilant. There, a company called Motorola runs. There are a couple others that are quite big, and they all have this database model. So police departments can opt in. Sometimes they're automatically opted in and they don't even know it, but opt into sharing, right? So they get access to other jurisdictions, and other jurisdictions get access to them. And it's not just sharing of police gathered data, but these companies are also selling this technology to private entities, sometimes other government entities, right? So maybe it's, the school bus, maybe it's a private school bus company, maybe it's like the school bus division of the whatever education department, but they're also selling it to private homeowners associations, to repo companies are a big buyer of this, right? Because they go around and they're just driving around constantly scanning license plates to see if anything matches their hot list of cars that they can repossess. But they and these companies that are providing them the cameras have realized, whoa, we can make a whole lot more money if we don't just let it alert in your tow truck that you just passed a car you can tow, but we're going to feed everything, including all the cars not on the hot list, into this database, and cops are paying to access it. Great. Yep. That's like cash in hand. That's cash in hand at the price of our privacy, obviously. Yeah. And it means that police and private companies are sitting on billions and billions of location points, charting our movements over time. And so we've started to see cases, and the ACLU has been filing friend of the court briefs in a number of them, challenging this unfettered searching, either the collection or the searching of the location databases. And there are a number of courts who have looked at these and said, a lot of the cases are arising in criminal prosecutions. And in many of them, it's actually a small number of location points that are relevant, that are kind of at issue, right? Like police want to know if the suspect was at 5th and Main on last Tuesday. Right. And so they just do a limited search like of last Tuesday. And courts have largely to now said, well, that doesn't look like the whole map of your life that we had in Carpenter over weeks and months. So we're not going to say that's a violation. But some of the courts have said, if a case comes back to me involving police actually querying a long duration or a long enough duration of this, that you can start to actually chart out what in Fourth Amendment terms is sometimes called the privacies of life, right? All the details of your life. Maybe that's a different decision. Maybe that actually looks close enough to Carpenter. And so what we've been doing is really trying to explain to courts how this ability to query these databases looks just like the intrusion in Carpenter, right? And actually worse in that in the Carpenter decision, police had to have a suspect first, right? Timothy Carpenter was the guy they wanted to know where he was on certain days. And so they narrowed in on him. The license plate reader databases, I mean, you can search for a particular plate, and police often do, but it's a database of everyone. And so you can also search for all cars in this neighborhood on this day, all cars that pass by this area at this time. And on top of that, AI algorithms are now being applied. So some of these companies are marketing the ability to actually have kind of like automated analysis to flag what they call suspicious driving activity, or to do convoy analysis, right? So we want all instances of 2 or more cars that are seen together on 2 or more times, right? Now that could be like, when I was in high school, I drove around with a crew of my friends through the back roads of Maine, like interminably, right? Were we up to no good in the sense that like we weren't doing anything productive, but like, no. But that's the kind of thing that would get flagged there. And so there are all kinds of privacy risks of both of just knowing where everyone is all the time, and then of AI on top of it, making assumptions about what's okay and what's suspicious, and then police potentially taking action on that.
I mean, I've been following this flock thing for a long time and all sorts of related stories. And there's been, obviously people are people. So you often find that people who have access to this are abusing it for other personal reasons. They're tracking, jilted lovers or whatever, or just stalking people in general. I know that to the AI point you were making, that they were looking for certain routes that they considered like drug routes. So if your car goes to this particular area and stays for a half hour and then comes back, that looks weird, because we know a lot of drug trafficking goes on there. So we're going to pull you over. But then I also just saw that recently the FBI has just come out and said, we put out a contract. Like we want to establish a contract with 1, maybe 2 of these license plate reader companies so that we could just have a database. And we're going to ask, we're just directly asking for direct access to all this information. And it's scary. And I've also heard things like that. They're starting to use, perhaps facial recognition. If they can see you through the glass, because they're looking at license plate, which usually on the back of your car, sometimes they're even noting things like car color, make, model, damage, bumper stickers that you might have that make you unique. But I guess bumper stickers also could tell you a lot about your personality. If I want to search for everyone with a pride flag on the back of their car, apparently that's something that might be doable at some point. There's a lot of really disturbing things that can be done with all of this data.
Yeah, it's absolutely true. And there's this kind of like AI functionality that they're putting on top. The video analytics is letting them do all those things, right? Show me every blue Ford that has gone by, every pickup truck with a ladder on the roof. I want all red cars, on these days. I want all cars with this license plate. I want all, whatever it is, these companies are selling the ability to search for. And, there are questions about accuracy, of course, right? Like getting it wrong and sending police off. And that's true even for license plates, right? This is, optical character recognition in suboptimal lighting conditions. And there are examples around the country of the computer just misreading a plate. And then police, stopping people, often at gunpoint, right? Pulling people out of a car, right? There are reports of families with kids being ordered down to the pavement, on their stomachs at gunpoint. And then police realize when they later then rerun the plate, like, oh, whoops, this is not the stolen car, right? This is not the armed and dangerous felon that we thought we were looking for. This is like a Sunday drive by this family. So there are lots of problems, but the one that we are at the fore most concerned about is this tremendous privacy problem of a database of at least weeks and often months of location information with unfettered access. And at a bare minimum, you got to apply that warrant rule. Right? If police want to dip in and figure out everywhere I drove over the last week or month, they better have a good reason. That's probable cause. And a judge better have agreed. And then they should be constrained, right? Because they have good reason to think I was running guns or whatever it is. Okay, they can check that, but not on a hunch, not also my brother, not, there got to be limits.
All right. So coming back to the border and tying this all together, does the border area itself, because you've already convinced me or told me that it's different at the border versus this 100-mile range thing. But, and this might be speculation because I'm not sure that we've hit this yet, but do you imagine that things like ALPRs and whatever, will they have similar loose interpretation and more broader use without warrants in these areas because of those same rules?
I'm not sure that that's exactly the risk. I think that the risk that I see more prominently is that these technologies often originate at the border or in sort of, quote unquote, national security policing or intelligence. But the border is often the place where you first see them. And then they start to creep into the country. And so, this is something we're seeing around facial recognition technology right now, right? So CBP, Customs and Border Protection, now uses face recognition technology as part of the entry-exit verification program. U.S. citizens are supposed to be able to opt out, although we've heard lots of intakes, lots of accounts from people who say, I don't want to do that. And some officer says, nope, give me your face. But we're seeing that creep into the country now, right? Like ICE and CBP are now using a facial recognition app during stops on the street. Yeah. They've used it more than 200,000 times. And we're afraid that local police are going to get the idea that they should be doing the same thing, right? And so a technology that started in what was supposed to be a very narrow border security context starts spreading. We've seen other kinds of technologies, right? There's a cell phone tracking technology that's called a cell site simulator, sometimes called a Stingray. It's a device that mimics a cell phone tower and forces or tricks phones in the area to talk to it instead of the real cell phone network, and then can track and identify phones. That started as a technology marketed to U.S. intelligence agencies and the military. And then the company kind of saturated that market. There was one primary company, and they have a profit motive. They have shareholders. Right. So what are they going to do? Find more buyers. So first they're going to go to the FBI and the DEA and the ATF. Then they're going to go to the IRS. And then they're going to go to the NYPD and the LAPD. But then they're going to saturate. So they're going to then just keep going down the line. And suddenly you have, small towns in middle America that are spending $100,000 of federal grant money on a device they don't need, and that poses tremendous privacy risks to people who are just living their lives.
Okay, so let's get into some practical advice. You knew we had to go there eventually. I usually like to wrap up with that. So I travel internationally very commonly, and recently when I was coming back, and even domestically, by the way, with the facial recognition stuff. Like I was coming through Vegas, and I think ironically, I was going to DEF CON, the hacker conference, and I was coming back, and I always try to opt out where I can just to test the waters, just to see if I can, what it's really like. Because it's one thing to say I could do it. It's another thing to actually do it. And is there social pressure too? Are there people behind me going, hey, come on, man, don't slow me down, by doing something special? Or the guy says, yeah, you could do it. Go to that long line over there, and then you can have your rights. I was at Vegas airport, and I told the guy, can I not do this? Because all of the checker sites I saw were all doing facial stuff. Can I not do this? He's like, look, you can, and then he pointed up the ceiling. And it's like, see all those domes? Those are all cameras. We've got your face 6 ways to Sunday. So you could avoid this one if you want, but we've already got your face. And so it's one of those things where there's what it says on paper, what your rights are, and then in practical use. So I found when I came back from Canada, I had all these plans of how I was going to do this. I was going to be in lockdown mode. I was going to turn my phone off. But I didn't practice it. And for example, the first person I met was, show me your boarding pass. I'm like, oh crap, it's on my phone. So I have to turn on my phone, unlock my phone, because I'm in lockdown mode, so it won't show it, on the screen. So I went through a lot of stuff. So help my audience understand what should we do at the border? If I'm planning an international trip, so when I come back, I'm going to be going through this. What would you recommend? How do I prepare my devices? How do I prepare myself? What should I be, mentally prepared for? I've seen all sorts of advice. Most of it seems impractical. What's your best advice?
Yeah. So one thing I'll say is, right, that, the privacy implications of actually, being pulled out of line and subject to one of these searches are extreme and extraordinary. But it is important to remember that as a percentage matter of people coming across the U.S. border, the hundreds of millions who come across every year, it's a very small percentage of people who are actually subject to a search of their phone or their laptop. So by pure numeric odds, the odds of any one of us being subject to that are not very high. Now, there are some people who are at higher risk, right? But, immigration status might make you at higher risk. nationality and background. That shouldn't be a ground, but Muslim American travelers for years have been subject to harassment at the border. Journalists have a lot to worry about. I'm an attorney with particularly sensitive information about suing the federal government, in fact, including DHS, right? So I take special precaution. So, you may know who you are if you think you're at special risk and might be particularly motivated to protect your files. But it does happen. It happens thousands of times a year to travelers. And the numbers of these searches go up year after year. They continue actually through both, Democratic and Republican administrations. They've gone up basically every year, occasionally little dips, but the trend line is the same. So you should plan ahead, right? You don't want to be in that secondary inspection room thinking about this for the first time, because that's too late.
Right.
Nothing you can do there. The best protection is not to be carrying the data you don't want the government poking around in.
Right.
So really the only durable, surefire thing you can do is not have the data on you. And so that might mean using a travel-only device, right? So, I know people who, when they have to take a laptop for travel, they bring like a netbook, right? They have a dedicated cheap computer that does everything online. Everything's through the cloud. Other than operating system, there's basically nothing saved on it. And you put it in airplane mode and you power it down and you get to the border and sure, they can see your operating system if they want, but that's it. With a cell phone, that's harder. Mm-hmm. Sometimes when I travel internationally, I travel with a separate cell phone, right? That has much less on it. And that way, if the government takes it and is looking through it, they can't see the stuff that I'm most concerned about, right? My sensitive client files, emails with clients, my family photos that I would just rather nobody's looking at, right? Just not carry them. Everyone's going to make their own risk assessment and kind of convenience assessment about whether that's worth it, whether that's too expensive, whether it's too much of a pain. There are also things you can do without a separate device, including using the online backup function, right? The encrypted backup. So one thing you can do is use your normal phone and then make sure it's totally backed up to the cloud. And before you get off that plane and are walking to the border checkpoint, you do a factory reset, you wipe it, and then better hope you don't need to use that phone in the next half hour. But then you get home later and you're in the cab and you start the backup restoration process and it downloads everything. That's a pain. It takes time. Sometimes it's a little glitchy, but it does mean that the phone doesn't have your stuff on it when you're there. One thing that's important for people to remember is that just sort of deleting file by file on a device doesn't actually necessarily mean that the file is deleted in a technical sense from the device. So usually when, just as a user of the interface, when you're deleting something, it disappears for your purposes, right? But it doesn't mean the file has actually disappeared from the device. Often it's just transferred to what's called unallocated space, and it sits there until it gets overwritten by some new computer file, which maybe that's 20 minutes from now, or maybe it's next year, or maybe it's never. And it's just you have no control over that unless you're a very sophisticated computer user using an operating system that is not what is built into these devices. And so stuff that's deleted is not going to be seen by an agent doing a manual search, but it can be seen in a forensic search. And that's part of what's so powerful about forensic searches. Even stuff that you thought you weren't carrying across the border might be visible. So that's important to remember. So rule number one, if you don't want it seen and searched, take care of that before you get to the border. Short of that, there are a few things that you can do that might help protect if you get to the border and there's stuff on there that turns out you wish the government wasn't getting access to. So putting the device in airplane mode yourself is a good idea. Not perfect. Of course, an agent who wants to violate the rules could take it back out, but at least you're helping protect your stuff that's in the cloud that even the government acknowledges they shouldn't be looking at the border. Having a strong password on the phone, not a biometric unlock, not a thumbprint or a face print unlock, but a strong passcode is important if you think you might get in a situation where they're trying to get in and you want to stop them.
Because let me pause for a second there. So because there's a difference between asking you to bio unlock your phone versus provide a PIN, correct?
That's right. There's a difference for Fifth Amendment purposes under the law. The Fifth Amendment, among other things, protects us against self-incrimination, being forced to incriminate ourselves by the government. There's a whole set of complicated doctrines there, but in the cell phone context and laptop context, the kind of TLDR is that if the government is trying to force you to divulge the contents of your mind like, in other words, a passcode or a password, then that is said to be like testifying against yourself. You're providing information that's against your interest. They're forcing you to, so they can't actually force you to do that. But if they are holding up a device to your face or putting your thumb down on the device, you're not divulging anything that's in your head. That's just like a feature of your body that's kind of exposed and that they're exploiting. And so some courts have said that's okay, right? Can't force someone to give up their passcode, but you can hold the device in front of their face without their consent. So yes, there may be a difference there, and a passcode is better security, both because you control it. They can't hold your device up to your passcode that's in your head, and also for those legal reasons.
So not to get way in the weeds, but I've got to ask, you said some courts. This has not been settled all the way up to the Supreme Court, right? So there's like some district areas where this has gone to the district level, and there's precedent in that district, but not nationwide yet for some of those rules that you're talking about. Yes,
that's right. That's totally right. It's a real mismatch. This Fifth Amendment question actually has mostly arisen not in the border context, but in the context of people who are arrested or under investigation, and the police have a search warrant for their phone, but can't crack the password, and so they tell the person, "Give us the password," and the person says, "You can't make me." And there's all kinds of litigation around, can they be held in contempt and jailed until they give the password? Can they be forced to? And what's the difference between facial unlock or biometric unlock and a passcode? And most courts have distinguished between the password in your head and the biometric on your body, but it's inconsistent. And yes, the Supreme Court has not taken it up yet. They should. The Supreme Court should also take up this Fourth Amendment question about what protections you have for your device itself for the search, but hasn't done it yet. We've tried, and they're not ready for it for whatever reason. So the next kind of stage, if you're at the border, right, is now you have a device, it's powered down. That's good because the kind of disk encryption is often the most secure if you're going from totally turned off to the first turn on, as opposed to screen lock to
before first unlock and after first unlock.
Exactly. So, most secure, it's actually powered down. You have a strong passcode in there. If you get up to the passport station, that's not the officer who's ever going to do the search. They're going to send you to what's called secondary inspection, which is a very unpleasant room over to the side, probably with no windows and a bunch of hard plastic chairs. And then you may get sent into an interview room, which is small and nobody wants to be in. I was sent to one once. It's no fun. And that's the circumstance where an officer might take your phone. They claim the power to take your phone without your consent, obviously. That's a corollary to their asserted power to search it. The government does not have the actual power to compel you to unlock the phone or to provide the passcode. Sometimes they will claim that. They will tell travelers, you must tell it to me, but they can't actually compel you to do that. However, it's pretty coercive, and you have to make a choice, because the consequence of not facilitating the search, in other words, giving them the passcode, is that they may let you keep going. They may let you go home after a couple hours, but they may hold your device. And we've had clients and heard of other people who have lost control of their phones or laptops, certainly for weeks and often for months. We had a client who was 7 or 8 months, they didn't have it. And during that time, your device is now being shipped off to some forensic search facility that DHS runs, and it's sitting in a queue waiting for a forensic examiner to go in with the newest tools that they've bought from a surveillance vendor. There's an Israeli company that sells a lot of these. There are a couple other competitors, seeing if they can crack the code. And there's a constant arms race between the operating system makers, right? Yes. Google and Apple primarily for cell phones, but also the Microsoft and Apple for laptops, and these surveillance vendors that are trying to crack them. And so you never know whether at any given time your version of an operating system on your device is going to withstand those attacks, or whether they're going to get into it eventually. But you may be without your device for a long time while they try. So the choice is, give up your privacy, give them the passcode, let them do the search, and leave with your phone, or stand on your privacy, make it hard for them, but go home without the device that you were expecting to have to call your Lyft, right? And that's a hard choice to make. And a lot of people at that point, everyone makes their own choice. And a lot of people decide, man, I really need this phone. I'm just going to cave. And if that's the choice you have to make, that's fine. And some people decide, it's worth it to me to buy another phone, and I have stuff backed up, and hell no. And I'm going to make it hard, and then you just see what happens.
Well, I think if you can afford it, I think that goes back to the argument for bringing a second device, because I don't know about you, but if my device was confiscated, I would never trust that device again. Yes. As far as I'm concerned, that phone's dead to me. I don't want it back. You could just keep it. I mean, I guess I could try to resell it or something, but given what they could do with some of those things, and I know this is a little black helicoptery, but I mean, if they've got full access to your device in the security world, we say that all bets are off. They could do, who knows what they could do, and you don't, and you probably can't tell when you get it back. All right. So a couple odd cases that I've heard that I just want to test with you since you're a lawyer. You mentioned it, specifically cases where lawyers have privileged stuff on their phones, or I could also see where if this is a corporate device, or even if it's a bring your own device for a corporation that's got corporate secrets on it or intellectual property, it's in a way not my device. In fact, I've heard weird things like someone says, well, start an LLC, make yourself the CEO of that company. Now this is a company device. You can't give permission for that because it's a company device, not your device. Weird angles like that. Does any of that come into play? Does any of that give you any special privilege if the data on there is not yours, but you have to protect it legally?
Yeah. Probably not in a meaningful way when you're actually at the border. Lawyers with attorney-client and attorney-work product privilege materials are the special case. That's the one category of data that the government policies themselves recognize have to get some protections. Those protections are like kind of complex. There's a whole process. The lawyer's supposed to invoke the privilege to the officer, then it goes to a supervisor. The lawyer's supposed to designate exactly what's on the phone that's privileged, which, if I'm carrying my normal phone, right, like I have like privileged materials, like it's all through my emails. It's like, screenshots of emails that I've saved in the photos. It's like everywhere. So that's not reasonable. But then if the government insists on searching, then they're supposed to refer the phone to a government attorney who's then supposed to get like it's like a clean team involved to do the search and only turn over non-privileged stuff to the actual border officer. I haven't seen this process get invoked very often at all. I have seen in the last year and a half or so a few examples of reports of lawyers coming into the country where border officers insisted on searching their phone. In one case, it was a lawyer from Michigan who was representing some clients who were accused of breaking the law somehow during a protest, a high-profile protest, and he was pretty sure that the government was coming after him because it wanted information about his clients. And he was basically able to talk the agents down from what they first wanted to do, which was a full search of his phone. And instead, he showed them, I think it was maybe a part of his contact list. And he just made the decision that, like, I need to get out of here, and I'm going to show them the minimal thing that will satisfy them, and then I'm leaving. Other lawyers may be able to prolong it later and negotiate their way out of it or get a court involved. But short of that, the government policy recognizes that there are other kinds of data that may be particularly sensitive, right? Trade secrets, business confidential information, medical information. And it has this kind of like weak language about how, that should be treated in accordance with other federal laws and privacy protections, but it doesn't set any limits on the search. And so, it's not a bad idea, I guess, to, you could carry a letter from your employer saying this traveler does not have the authority to consent to a search, right? Call our general counsel. Like, that's a great idea. Why not try it? But I have no confidence that that's going to win the day when you're sitting in a room without access to a phone, right? They're not going to let you call anyone, almost certainly, and they're insisting on searching. Maybe refusing to unlock it for them means that they then have to let you go and they take it away, and then you contact your company's lawyer and they get in touch with the government, and maybe that kicks off something that can protect, but it's hard to know. And there's no like one quick trick, right? Like making yourself an LLC is not going to save you. Maybe it complicates things a little, but like I really doubt that's the thing that nobody has thought of yet.
All right, one more thing. It's because I just saw this in a weird video. There was a cop pulled somebody over, asked to see their device, and right before the guy was going to hand him the phone, he realized his phone was on and unlocked, so he just went to push the power button. And the cop snatched it out of his hand. Seeing that he was going for that, claimed that he was trying to delete something. But that basically let him get access to the device before it got locked. He wasn't even able to power it off. That's a very weird specific circumstance, but I guess the broader question is there anything that I might do or not make sure I don't do at the border that would make me more susceptible to being searched, make me suspicious, piss off the guy, because I know that's really a lot of this in their discretion. Is there something that I should definitely avoid doing? And then if they ask me to see the device, do I have the legal opportunity to power it off, to either all the way down or or lock it, or maybe there's a special thing on an iPhone where you can hit it 5 times and it locks it out so you have to use a PIN code. Am I allowed to do those things before handing it over?
These are all kind of unanswered questions, and it may just depend on the context. So I think it's impossible to give advice ahead of time, except to say that, consistent with what I was saying earlier, the best protection is stuff you do ahead of time. Don't rely on the ability to do some quick thing there. I have seen the government prosecuting people who had security measures on a device where there's the real unlock code, and then there's a wipe code, right? And where they, give the government agent the wipe code and instead of the unlock code, and then suddenly it's very hard to recover data. That may be a clever, effective fix, but there may be some real legal risk there in practical terms. So, it's impossible to give it advice, except if you want to do something, you should do it before you step up to that counter.
All right, last question before we go. Here's an easy one. What's next for you? What cases are you working on? Where the ACLU's efforts being focused right now? And then if we want to help support you guys do what you do, how can we help?
That's great. Well, second part first, we have a website, aclu.org. You can support us through monetary donations. You can support us by taking actions, right? There are lots of ways to contact lawmakers, the state level, the federal level. That's really important. There are events that our state affiliates are hosting all the time. I work for the national ACLU, but there are ACLUs in every state. They're working in state houses and city councils. There are ways to organize, to push for ordinances to protect us against unjustified surveillance that require transparency, that require warrants, that take certain things like abusive facial recognition technology just off the table for law enforcement. And all of that is important, right? Use your voice, use your wallet.
Yes.
What are we working on now? So just yesterday, I'm part of a legal team that filed a wrongful arrest lawsuit on behalf of a Florida man who was picked up after facial recognition technology misidentified him. This is a man who lives in Fort Myers, which is kind of middle Florida on the Gulf Coast, arrested at the request of police in Jacksonville Beach, which is 300 miles northeast on the Atlantic coast, a city he has literally never in his life been to. But police were investigating a attempted child luring in a McDonald's. And they had surveillance footage from the security camera, ran it through this face recognition technology. It misflagged our client as a match. And police then did a whole bunch of other wrong stuff, but then got an arrest warrant and totally turned his life upside down. Really just a terrible ordeal. So we're now suing the police in Florida for that wrongful arrest. We're filing lots of briefs about location tracking technologies, automated license plate readers we talked about, other technologies. We're now waiting for a decision from the U.S. Supreme Court in a case about what are called geofence warrants.
Yes.
It's another kind of location data that Google used to hold. They now no longer can actually comply with these government requests because they changed how they save it. They moved it from their servers to people's devices because they just wanted to be out of the surveillance business in this particular narrow area. But there are a bunch of legacy cases, and the Supreme Court is going to decide in the next 3 to 4 weeks whether a warrant is required and what that warrant should look like to get location information from Google about who was in a particular geographic area in a particular time frame. That's an important one that we filed a brief in. These questions they're going to keep coming up and keep morphing as the technology changes. And there are some commonalities and some ways in which technology changes. And so, we're never going to get to a resolution point. But the hope is that over time, the arc of protections is going to track the development of the technology.
Bend toward justice, indeed. All right, Nate, thank you so much. It was great to talk to you again. We'll have to do it a little more sooner before the next time we bring you back.
That's a deal. Great to talk to you.
So good to talk to Nate. It's been too long. I've been thinking about getting him back on the show for a long time. So I'm glad we found a good topic to discuss, and I'm glad we got him back. Nate's a great guy. That was very informative and really goes to show how our laws just have not kept up with the digital age. And we need to get that straightened out here pretty soon because it's not getting any better. I remember when I first started going to hacker conferences that I kind of had a similar vibe. Like, how do I prepare my devices for this? What precautions should I take? I mean, I'm going to a hacker conference, for goodness sakes. I struggled with that before I'd ever gone to my first one, read all sorts of things about it. And in the end, kind of like here, there's some good precautions to take. There's some basic things you should do. You should figure out, as always, what your threat model is. and figure it out before you go. Because you definitely don't want to have to figure it out in the moment. That's a bad plan. That's actually no plan. Now, we didn't really talk about this in the interview, but given my current kick on communal privacy, you should also be considering whether the information on your devices about other people might be problematic. Are there pictures, emails, text messages, signal messages, shared documents, shared folders that could cause grief for others if they were to be viewed by, law enforcement or border agents or whatever? Again, your privacy overlaps their privacy. We need to be thinking about them as well. So keep that in mind as well as you're thinking about whatever your plan's going to be if you're worried about some data on your phone being visible to the border agents or law enforcement or whoever. So I did a couple blogs on this that you might want to check out. They were called Travel Insecurity. I put a link to the show notes about my thinking on this and what I did when I recently crossed the border and how I prepared and how that plan actually held up when I actually did it. And I've done some interviews about this as well. I had one with Deviant that was pretty interesting. And also we talked about Stingrays, which is a brand name for a particular type of cell site simulator, but there are others. I did an interview about these Stingray devices with Cooper Quinton from the EFF. That's a fun one to go check out if you want to learn more about those. And you could always go back and check out my original interview with Nate about location tracking in the Carpenter case. All right, so patrons, you will get some bonus Q&A with Nate on Thursday morning as usual. I ask him about Facebook's video glasses and technology like that, about our expectation of privacy when everyone is wearing some sort of device that's recording everybody else. And he definitely had some interesting things to say about that. So that and more will be there for patrons on Thursday morning. Looking ahead, I'm going to be finally, I hope, by the next podcast, telling you what my plans are going to be for celebrating the 500th episode of the podcast. Some things are still in flux. I'm still trying to figure out exactly how I want to approach this. It's going to be interesting, but I'm hoping you'll be able to help me out. This is a little campaign I want to do for the 500th episode to try to help people out. So there's your teaser. Hopefully I'll have more details for you very soon. That's going to do it for this week, everybody. Take care, stay safe out there, and until next time, as always, don't get caught with your drawbridge down.